The Attorney General who promised to end political prosecution just became its most ironic victim. What unfolded during a routine congressional hearing wasn't just embarrassing, it was career-ending, freedom-threatening, and completely self-inflicted. Pam Bondi walked into that chamber expecting another day of deflecting questions. She walked out having confessed to crimes that could keep her behind bars until she's too old to remember why she's there. Early December 2025, the Senate Judiciary Committee convenes for what everyone assumes will be standard government oversight, budget talks, policy questions, the usual Washington theater. But Democratic senators have been preparing something different. They've obtained court documents that don't just raise questions about the Justice Department's conduct. These documents prove systematic constitutional violations orchestrated from the very top, and they have receipts. Attorney General Bondi settles into her seat, flanked by advisors, prepared with the standard playbook of evasion. Ongoing investigation, can't comment on pending matters, classified information protocols. She's done this dance before, but today the music stops abruptly when Senator Sheldon Whitehouse produces a blue folder containing evidence that transforms political theater into criminal exposure. The Torres case seemed straightforward at first. Prosecution of a former Biden administration official for classified information leaks. Standard political payback dressed up as law enforcement. Except there's a problem that goes far beyond politics. The prosecutor running the case, Marcus Denton, was never legally appointed according to constitutional requirements. Not a paperwork mix-up, not a technicality, a fundamental violation of the appointments clause that every first-year law student learns about. When defense attorneys discovered this flaw in October, they did what any competent lawyer would do. They filed motions to dismiss based on constitutional defects. The entire prosecution hung by a thread, and that's when Bondi made the decision that would define her downfall. Instead of acknowledging the mistake and fixing it through proper legal channels, she chose deception. She ordered staff to create appointment documents and backdate them to August, months before the problem was discovered, creating a false paper trail suggesting Denton had been properly authorized all along. Think about what that means. The nation's top law enforcement officer, the person sworn to uphold constitutional integrity, deliberately falsified government documents during an active federal prosecution to cover up violations she knew existed. Not alleged violations, not disputed interpretations, violations her own Justice Department lawyers had explicitly warned her about in writing. The emails are damning. October 7, 9:47 a.m. Deputy Assistant Attorney General Sarah Chin sends Bondi a message with the subject line, "Urgent, defect in Torres prosecution." The email details how defense counsel has identified the appointments clause violation and explains that all indictments face potential dismissal. 5 hours later, at 2:15 p.m. the same day, Bondi responds with instructions to prepare appointment documentation with effective date prior to case initiation. There's no ambiguity here, no room for interpretation. She received notice of a constitutional problem in the morning and ordered the creation of backdated documents that same afternoon. The timeline doesn't just suggest consciousness of guilt, it proves intentional falsification captured in her own written communications. Senator Amy Klobuchar walks Bondi through this timeline during the hearing, reading directly from internal Justice Department emails now entered into the congressional record. Bondi's responses become increasingly evasive, her earlier confidence crumbling as the documentary evidence builds an inescapable cage around her testimony. She tries claiming the documents merely clarified existing authority. She attempts bureaucratic word salad about formalizing intent, but Klobuchar cuts through every dodge with surgical precision. Then comes the moment that legal analysts will study for decades. Senator Richard Blumenthal, former U.S. Attorney and Connecticut Attorney General, asks the question that leaves no escape route. Did you sign documents after the fact and date them as if they had been signed earlier? 10 seconds of silence. 15. The cameras capture every microsecond of visible panic as Bondi realizes she's trapped between perjury and admission. Finally, she answers with bureaucratic deflection that Blumenthal immediately translates. That's a yes. With that single admission, Bondi confesses to federal crimes on live television before Congress and millions of witnesses. Title 18, Section 1519, Falsification of Records in Federal Investigations, 20 years maximum per count. Title 18, Section 1512, Obstruction of Justice, 20 years maximum per count. Title 18, Section 242, Deprivation of Rights under color of law when government officials knowingly violate constitutional protections. These aren't political accusations. These are specific federal felonies with statutory sentencing guidelines that judges must follow. The mathematics become terrifyingly simple. Multiple backdated documents equal multiple counts. Multiple counts at 20 years each, potentially consecutive, create life imprisonment exposure. Federal sentencing guidelines require judges to consider aggravating factors. As Attorney General, Bondi held the highest position of public trust in law enforcement. Violating that trust doesn't reduce her sentence, it maximizes it. But here's where it gets even worse for Bondi. Presidential pardons only cover federal crimes. Senator Cory Booker points out during questioning that document falsification also violates state laws in jurisdictions where those documents were filed. New York Penal Law Section 175.10 makes falsifying business records a Class E felony carrying up to 4 years per count. Multiple counts mean consecutive sentences, and state prosecutors operate completely independent of federal pardons. Even if Trump wanted to protect Bondi with a federal pardon, New York's Attorney General could pursue separate state charges that no president can touch. Virginia could do the same. She's facing potential criminal exposure in multiple jurisdictions simultaneously, and there's no single escape hatch that saves her from all of them. Perhaps most devastating is the bipartisan recognition that Bondi crossed lines that even political loyalty won't defend. Senator Lindsey Graham, typically one of Trump's most reliable defenders, delivers an assessment that destroys any hope of partisan protection. I've supported this administration, but I cannot defend these documents. The Appointments Clause is a constitutional mandate, not a technicality. Backdating government records to conceal violations is potential criminal conduct. If proven, I don't see how prosecutors decline charges regardless of politics. When you've lost Lindsey Graham on a matter involving Trump's administration, you've lost the only shield that might have protected you. Bondi's actions were so egregious that even senators predisposed to defend her couldn't find legal footing to stand on. The conspiracy expansion her exposure even further. Emails show multiple senior Justice Department officials were copied on communications discussing the documentation problem and the retroactive validation strategy. If prosecutors can prove coordination among officials who knew about the constitutional defect yet proceeded anyway, conspiracy charges under Title 18, Section 371 add another 5 years of potential imprisonment. Each participant becomes both a co-conspirator and a potential witness who might cooperate to reduce their own exposure. One email stands out for shocking candor. October 8th, the day after discovering the constitutional defect, Bondi writes to her Deputy Attorney General, "We cannot allow Torres' case to collapse over technicality. Prepare documentation packages with dates reflecting proper appointment timeline. Mark as priority." She literally calls a constitutional violation a technicality and orders the fabrication of backdated documents in writing. Defense attorneys couldn't ask for clearer evidence of criminal intent. The immediate aftermath moved with remarkable speed. Within hours of the hearing, former federal prosecutors across the political spectrum published statements declaring that Bondi's admissions created a prosecutorial obligation. Constitutional scholars from left and right agreed that backdating government documents during active prosecutions meets every element of obstruction of justice. By December 5th, the Justice Department Investigator General announced a formal investigation into document authentication. By December 12th,
New York's Attorney General announced a parallel state investigation into falsification charges that no presidential pardon can neutralize. Today, 1 month after that catastrophic hearing, Bondi faces cascading legal exposure with no viable exit strategy. Federal prosecutors review obstruction charges based on her own sworn testimony. State prosecutors examine falsification charges immune to federal pardons. Congressional committees prepare criminal referrals citing evidence already locked into the official record. Every word she spoke under oath becomes potential evidence in her own prosecution. The only traditional mitigation strategy available would be cooperation, testifying against other officials involved in the scheme in exchange for reduced sentencing. But cooperation requires admitting guilt, which carries unacceptable political consequences in Trump's administration. Loyalty is rewarded until it becomes legally suicidal, and Bondi has reached that threshold.